Dear friends, this is R.V. Shekhar, practicing company secretary. I'm going to explain in this video why we have to approach NCLT, National Company Law Tribunal. After the introduction of NCLT, the powers of the High Court has been transferred to National Company Law Tribunal. So whatever we have, if we have any grievances under the company's law, under IBC, then we have to approach only National Company Law Tribunal and not High Court, respective High Court. So, how NCLT is going to help us in resolving the issues under Companies Act? Expeditious disposal. Once we file the application with the NCLT, within 3 months of time frame, they have to dispose the petition and application. This is under section 422 of the Companies Act. For corporate disputes, only now NCLT has to be approached and not the High Court. And whatever the matters under the Companies Act, under the IBC, only NCLT is now empowered to hear all the hearings and not High Court under the section 430 of the Companies Act 2013. nCALT is the Appellate Tribunal law. If you have any issues with the findings of the NCLT, then you can apply to nCALT, Appellate Tribunal, which is located in New Delhi under section 421. Decision by nCALT can be appealed to Supreme Court. So if you do not like the verdict which was given by nCALT, then you can apply to the Supreme Court against that decision. Power of the contempt is now with the NCLT. Previously, it is vested with the High Court under section 425. Now, the power of contempt is now rest with the NCLT. Limitation Act also applied. See, when you apply to the NCLT, you have to see whether the appeal or the petition has been filed within the time allowed under the Limitation Act as per section 423 of the Companies Act. Can we cancel the AOC-4 and MGT-7 filed under STP mode? So this is one of the main topic. Says what are the companies if they file AOC-4 and MGT-7, and after that filing, if they found some defect is there, whether we cancel the file, because once we upload the same in the MCA, this will be under automatic STP process. Immediately it will be taken into the record. So once can we cancel it? Yes, we have to approach concerned ROC and give it an application in writing. ROC can cancel the AOC-4 or MGT-7 if it is found defective, thereby allowing to file a revised AOC-4 or MGT-7. As per Rule 10(6) of the Registration of Officers and Fees Rules 2014, in case the registrar of company finds any e-form or document filed under the straight-through process STP as defective or incomplete or in any respect, he should at any time suo motu or on receipt of information or complaint from any source at any time treat the e-form filed or the document as defective in the electronic registry and shall also send a notice pointing out the defects or incompleteness in the e-form or documents attached at the email address latest updated in the MCA site of the person or the company which has filed the document, calling upon the person or the company to file the e-form or document afresh, new, along with the fee and additional fee as applicable at the time of actual refiling or after rectifying the defects of or incompleteness within a period of 30 days from the date of the notice. This is if you want to cancel the e-form filed by you, AOC-4 MGT-7, you can approach the ROC and request them to cancel it and file a fresh AOC or MGT-7 in place of it. Then next question. What we have to do if ROC refuses to file revised AOC-4 or MGT-7? Suppose if you approach ROC and give a petition or application and ROC refuses to do that, then what is your next approach? Then you have to apply to the NCLT for allowing to file revised AOC-4 or MGT-7. If ROC refuses to cancel the AOC-4 or MGT-7 filed under SAP, a stakeholder can approach the NCLT for redressal of his grievance. In Promark Technologies Private Ltd and in Glaze Trading India Private Ltd, NCLT New Delhi allowed the filing of revised financial statements. When ROC refused, the company respective the Promark Technologies and Glaze Trading, they approached the NCLT New Delhi and got the permission from the NCLT New Delhi to file the new petition AOC-4 and MGT-7. Approaching NCLT for extension of AGM. So, due to some reasons, the AGM cannot be held within the stipulated time. So, the company may approach the NCLT for, and first they have to approach the ROC for extension of the AGM. Some of the reasons of the extension of AGM have been provided here and there. Due to non-signing of financial statement, due to non-availability of auditor, due to resignation, death, or incapacity to sign, or such other valid reason. The next reason is non-readiness of financial statement due to natural calamity, due to loss of financial data, or absence of directors. Natural calamity, see now corona is there. Due to corona fear, the financial statements of the company is not ready, or like that calamity, hurricane or flood, or due to loss of financial data due to hurricane or flood. So you can approach ROC to extend the date of AGM. Non-availability of managing director, since the financial statement need to be signed by the managing director. Non-availability of directors on the valid grounds.
Sudden death of directors and consequence of this, the limit of directors goes below the minimum requirement of the directors. If the level of directors, minimum directors have gone less than what is required under the law, then such a situation one can approach ROC for extension of AGM. Confiscation of books of accounts by income tax department or serious and fraud investigation cell or any other government officials, so customs or excise department. So in such a situation also you can approach ROC for extension of AGM. Such other special reasons, if such reasons are valid and justified. So you have to justify the reasons what you have found, then only you can approach the ROC for getting the approaching NCLT for extension of AGM. See, if the ROC refuses to give permission for extension of AGM, the stakeholder can approach the NCLT for extension of AGM. Under section 96 of the Companies Act 2030, ROC may, for any special reason, may extend the period for conducting the AGM other than the first AGM by not exceeding 3 months, 90 days. If ROC refuses to give his approval for extension, a company may approach the NCLT for extension of AGM. In Punjab National Bank versus James Hotel Limited, which is under IBC, the company was under IBC, the company was declared as an insolvent company under section 7 of the IBC code. Resolution person RP applied for extension of AGM because he cannot, because there was no cooperation from James Hotel for compilation of accounts, making audit and everything. ROC refuses to give his extension for this company, and the RP went to approach the NCLT Chandigarh for and the RP and the NCLT gave the extension. So overriding the rules decision by ROC, the NCLT came to the help of the RP and gave the extension. In Chennai NCLT, there is a peculiar case. Application has to be filed within a reasonable time for extension of AGM as per company law. What company law states, Companies Act states, application has to be filed within a reasonable time for extension of AGM. In one case, ROC rejected an application stating that the application has been filed on the last day allowed under section 96. They just simply rejected the application for extension of it, that the application has been filed on last day, not in well in advance, as stated in the section 96. The company appealed to NCLT Chennai. NCLT Chennai ordered ROC to give the extension of the AGM. So NCLT came to the help of the customer stakeholder and ordered the ROC to give the extension. Change of financial year, like this also, we can approach NCLT for change of financial year also. In Adva Optical Networking India Private Limited and another case, Higher Appliances India Private Limited, NCLT New Delhi allowed the change of financial year for the company as the company's subsidiary had a different financial year. So as NCLT took into the other aspects also, and it gave the permission for NCLT to go for further. And we can then the next one is conversion of public company into private company. We can approach NCLT for conversion of public company into private company. Radiant Chemical Company Limited, section 18. In this section does not prevent what NCLT held under section 18. This section does not prevent conversion of public company into a private company by alteration of its articles. This is one of the important decisions given by the NCLT. So whenever you feel anything to be given, see either it's the extension of AGM or other objects also, you can approach freely to the NCLT and request the NCLT to give extension for your company. You can approach also NCLT for reviving a defunct company. Since nowadays ROC is going on striking of the companies under section 252. If such company want to revive the company, they can approach the NCLT for reviving the struck off companies by ROC. In Rahul Rice Mills Private Limited, NCLT Delhi held that mere reason that directors are now ready to infuse funds into the company is not a valid reason for revival under section 250. So for revival, if you want to go to NCLT, you should have a very good justiciable ground. Then only you can approach the NCLT. Otherwise, NCLT will reject the application made under section 252 for revival of a defunct company. To take another company made another application to take advantage of the change in the government policies, company may be allowed to revive the company under section 252. In PKD Securities Limited versus ROC Shillong, at the time of strike off by ROC, the India Sensex market as indicator of the pulse market was just 3,000. However, Sensex rose to 30,000 mark in the year 2016, which indicated huge boom in the business concerned. As the government policies stand in favor of the business of the company may be allowed to take the advantage of change in business scenario. It was held by NCLT. It allowed the company to revive. So just applying to the NCLT for revival of the company under section 250 cannot be success. You have to give a valid ground for revival. You have to explain the judge, NCLT lords, to hear that is a valid ground, that you want the company to revive under the valid ground. Just now the directors are ready to infuse funds into the company cannot be a valid reason. You have to take into the care. Friends, if you like, say you have to approach NCLT, ROC and NCLT in case if you have any defect or grievances, and in case of extension of AGM either it is a revival of company under 252, or if you want to file a revised AOC for MGT-7. Thank you for viewing this video, and I request you to subscribe my channel so that whenever I issue new video, then it will come to you directly. Thank you very much for